You're trying to love this to death, aren't you?
I disagree.
You're not really for giving law enforcement the power to fight back, are you?
I am in favor of giving law enforcement that power and respecting constitutional limits.
I don't believe you, Professor. Okay? You're not talking to Bambi's baby brother here.
This Senate hearing exchange unfolds against the backdrop of a rapidly evolving national security challenge, the increasing use of drones by criminal actors. From smuggling operations along the border to surveillance over critical infrastructure, unmanned aerial systems have created new enforcement dilemmas that existing laws were not fully designed to address. At the center of this discussion is John Kennedy, who is pressing a law professor on whether proposed legislation gives state and local law enforcement sufficient authority to counter drone threats. The professor, in turn, raises concerns grounded in the Fourth Amendment's warrant protections, the First Amendment's free speech implications, and the 10th Amendment's balance of state sovereignty. This is not simply a partisan exchange. It represents a classic tension in American governance: how to respond quickly to emerging security risks while preserving constitutional limits that prevent government overreach. When technology outpaces legislation, lawmakers must decide whether to prioritize speed and flexibility, or constitutional precision. The moment we're about to examine highlights that collision between urgency and restraint.
The bad guys are using drones. Does anybody disagree with that? Okay. And the federal government has the authority to fight back, does it not? But state, nobody disagrees with that statement? Sure, Professor.
I would say within limits, yes. Within constitutional limits.
Okay. Do any of you disagree with giving state and local law enforcement the authority to fight back?
Again, within constitutional limits.
Okay. Tell me what your constitutional concerns are, Professor.
So I have three primary concerns. The first has to do with the Fourth Amendment and the conditions under which a warrant is required and a general warrant is forbidden by the Fourth Amendment. So in this particular case, it's important.
Professor, before you give me one of your lectures, are you saying that we should require state and local law enforcement to get a warrant before they fight back?
It depends on the condition. So in an exigent circumstance or something along the border.
I'm aware of the exceptions to the warrant requirement. But you, generally speaking, you want to require them to get a warrant.
Only for the search of a device or the seizure of property. There are also due process implications of that.
Mm-hmm. Okay. You started to mention another one of your objections.
First Amendment.
First Amendment. Okay. Any others?
Yeah, I also have a state rights, a 10th Amendment concern here, which is that states own the airspace adjacent to the land within their state that's not federally owned, and the current federal provisions don't recognize state sovereignty in that way.
So you want to give state and local law enforcement the authority to fight back, but you want to list a whole lot of conditions. Is that a fair assessment?
Not a whole lot, but some. There needs to be a nexus to the facility. It can't be any drone anywhere in America if you're concerned about a particular facility, but right now it's too broad. There have to be acknowledgments of First Amendment concerns. So for instance, limiting the covered facilities to the experience and logic test with which the courts use for right of public access, or prohibiting media bans across the board, or setting a time limit before and after special events so they don't extend extensively. This is what a number of state measures already do, and I'd like to see that at a federal level and apply to bring this within the constitutional limits.
Sounds like a lot of conditions to me.
No, not very many. As long as there's probable cause and the conditions are met, then absolutely you can.
Have you ever heard of a legislative practice called loving a bill to death?
Yes.
Okay. And that's when you take a bill and somebody says, I'm really for this bill. But then they add so many amendments, and they screw it up so badly that the bill either becomes ineffective or doesn't pass. Is that a pretty accurate description?
Of the term?
Yeah.
Yes.
You're trying to love this to death, aren't you?
I disagree.
You're not really for giving law enforcement the power to fight back, are you?
I am in favor of giving law enforcement that power and respecting constitutional limits.
I don't believe you, Professor. Okay? You're not talking to Bambi's baby brother here. Okay? I've read some of your stuff. I think you'd be more intellectually honest if you just come out and say, I'm on the side of the bad guys here. I think we shouldn't give state and local law enforcement the authority to fight back. You're trying to make it as hard as possible, aren't you?
We'll have to disagree on that point, Senator.
Nah. You know, you ever heard the expression, watch what they do, not what they say? I've watched what you've done. I know what you believe. Well, you're on the FISA court?
I'm not on the court. No, I'm an amicus for the Foreign Intelligence Surveillance Court and the Court of Review.
Okay. Were you there when you guys issued all those bad warrants against Trump's people?
I can't discuss my work on the court, unfortunately.
Oh, it's top secret, right? You'd have to put me on the American people on double secret probation if you told them the truth, wouldn't you?
At this stage in the exchange, the philosophical divide becomes clearer. Senator Kennedy frames the issue in practical, operational terms. His concern appears to be that layering too many procedural requirements onto enforcement authority could render the law ineffective in real-time situations. The phrase, "loving a bill to death," reflects a legislative critique, the idea that excessive amendments or conditions can weaken a bill's intended impact. The professor's response, however, operates from a constitutional framework. Her mention of warrant requirements, due process protections, First Amendment concerns, and state sovereignty reflects long-standing judicial doctrines. The Fourth Amendment limits unreasonable searches and seizures. The First Amendment protects lawful expressive activities, which could include certain drone uses by media or private individuals. The 10th Amendment addresses the balance between federal and state power, particularly relevant when federal statutes intersect with state-controlled airspace concerns. The tension here isn't necessarily about whether law enforcement should have authority, it's about how clearly and narrowly that authority is defined. History shows that emergency powers, once granted, can expand beyond their original scope if not carefully constructed. So here's the larger policy question: when lawmakers design security legislation, should they assume good faith implementation and grant broader discretion? Or should they draft narrowly tailored authority that anticipates potential misuse? That balance between flexibility and constraint lies at the heart of this exchange. This hearing moment reflects a broader structural challenge in American lawmaking. Emerging technologies, from drones to artificial intelligence, often create security gaps faster than Congress can legislate. When those gaps become visible, lawmakers face pressure to act decisively. But decisive action must still operate within constitutional boundaries that were intentionally designed to limit concentrated power. Supporters of expanded authority argue that law enforcement cannot afford bureaucratic delays when confronting real-time threats. They contend that excessive legal hurdles may create vulnerabilities that bad actors exploit. From that perspective, streamlined authority is not overreach, it is preparedness. Critics counter that constitutional safeguards are not optional technicalities, they are foundational guardrails. Requiring warrants, defining clear jurisdictional limits, and protecting lawful expressive activity are mechanisms designed to prevent unintended harm to civil liberties. In their view, speed without precision risks long-term consequences that outweigh short-term gains. This debate ultimately reflects a deeper American principle: security and liberty are not mutually exclusive, but they require constant recalibration. Each technological shift forces lawmakers to revisit where that line should be drawn. So we want to hear from you. Should Congress prioritize rapid enforcement authority in response to drone threats? Or should constitutional constraints remain the central focus, even if that slows implementation. Share your thoughts respectfully in the comments below. If you value thoughtful, fact-driven analysis of major Senate debates, without sensationalism, be sure to like this video, subscribe to the channel, and share it with others who want deeper insight into the policy decisions shaping national security today.